The Principles and U.S. Federal Rules of Civil Procedure. Civil procedure is the body of law that sets out the rules and standards that courts follow when adjudicating civil lawsuits, as opposed to procedures in criminal law matters. These rules govern how a lawsuit or case may be commenced, what kind of service of process, if any, is required, and types of pleadings or statements of the case, motions or applications, and orders allowed in civil cases, the timing and the manner of depositions and discovery or disclosure, the conduct of trials, the process for judgment, various available remedies, and how the courts and clerks must function. Early federal and state civil procedure was rather ad hoc, and was based on traditional common law procedure, but with much local variety. There were varying rules that governed different types of civil cases, such as cases at law, or in equity, or in admiralty, and these differences grew from the history of law and equity as separate court systems under English law. Even worse, discovery was generally unavailable in actions at law. In order to obtain discovery, a party to a legal action had to bring a collateral proceeding, a bill in equity in aid of discovery, just to obtain essential documents or testimony from the opposing party. The Conformity Act of 1872 directed federal courts to conform to the civil procedure of the states in which each federal court was located as much as possible, though federal courts were allowed to continue to develop the federal common law of evidence, most of which was replaced a century later by the Federal Rules of Evidence. However, state civil procedure law continued to diverge, particularly when some states, but not others, began to replace common law pleading with code pleading. The inevitable result was confusion and chaos in the federal courts, particularly as interstate commerce escalated with the Second Industrial Revolution, and an increasing number of cases between citizens of different states were heard in federal courts under diversity jurisdiction. Therefore, the United States federal court system adopted standardized federal rules of civil procedure in 1938, which unified law and equity and replaced common law and code pleading with modern notice pleading. Most states have also adopted the federal rules to govern civil procedure in their state court systems, although significant modifications were necessary because the federal courts are courts of limited jurisdiction, while state courts have general jurisdiction over innumerate types of matters that are usually beyond the jurisdiction of federal courts, such as traffic, family, probate, and so on. A few states have adopted the general principles that civil procedure should be established in court rules, not civil procedure statutes, but have refused to adopt the FRCP, Federal Rules of Civil Procedure. For example, Rhode Island has its own civil court rules of procedure. California and New York are the odd exceptions, in that almost all of their civil procedure systems are codified in statutory law, the Code of Civil Procedure and the Civil Practice Law and Rules respectively, not in rules promulgated by the State Supreme Court or the State Bar Association. Civil procedure involves the selection of an appropriate court to hear a particular case, and following certain procedures when dealing with the court and other parties. In selecting an appropriate court, there are three important factors to consider. The court must have jurisdiction over the parties, must have jurisdiction over the subject matter of the case, and must satisfy rules regarding venue. Venue refers to the selection of the most appropriate county or district to hear the case. After the court has been selected, and there may be several alternatives to choose from, the parties must follow the appropriate procedures regarding service of process, the complaint and other documents forming the pleadings, the joining of multiple parties and claims, the sharing of evidence and other information in the pre-trial discovery phase. Certain rules must be followed with regard to how prior judgments, often judgments from other courts, affect the case in hand. Then when it comes to trial, there are established rules to determine all aspects of the trial and the subsequent appeals. The US Constitution creates a federal system of government in which power is shared between the federal government and the state governments. Both the federal government and each of the state governments have their own court systems. The judicial power of the United States is vested in the federal court system. The Constitution also creates the US Supreme Court and gives Congress the authority to create the lower federal courts. Every state in the United States has its own court system to hear cases arising from that state. Suppose that a citizen of Mississippi sued a citizen of Alabama in a case involving a real estate transaction that took place in Georgia. The case could be brought in state court in Mississippi or Alabama because of where the parties live, or it could be brought in Georgia because of where the property at issue is located. However, such a case could not be brought in the state of Alaska because none of the parties live there and the state of Alaska has no attachment to the case at all. The Alaska court would dismiss any claims in this example because it would not have the appropriate jurisdiction. No federal court has subject matter jurisdiction to probate a will. The probate process has traditionally always been left up to the individual state courts. In contrast, cases involving patents are always in the subject matter jurisdiction of federal courts. Because the Constitution gives Congress the specific power to regulate the patent system, state courts do not have the appropriate jurisdiction to hear patent cases. Federal courts also have exclusive subject matter jurisdiction over copyright cases, admiralty, lawsuits involving the military, immigration laws, and bankruptcy proceedings. However, in most other matters, state and federal courts hold concurrent subject matter jurisdiction. Claims arising under federal law may be heard in either judicial system. Both plaintiffs and defendants may choose between state or federal. A defendant has the general right to remove both federal question and diversity cases from state to federal court. However, only a non-resident may remove a diversity-based state law claim to federal court.